if I may, I believe at this point in time the state's going to be arguing proof evident, so they'll be requesting zero bond. So if the state would like to proceed first, if that's how you'd like to go forward, Your Honor.
All right, go ahead.
It's the state's position that the 32-page affidavit sets forth proof evident presumption great.
All right.
Your Honor, if we take a step back at the affidavit, excuse me, the 32-page, I believe that we just jump right to the end of it, page 30, 31, and 32, which are the conclusion of that are made in the warrant. Right off the bat, I put each bullet number, and there's 13 bullet numbers. Number 2, the second bullet number discusses my client. After that, there's no more discussion of my client. So we jump to the second bullet. Specifically within there, the main players of this are Mr. Cardenas, Mr. Pope, and Mr. Prasad. Those are the main players. Again, we jump to the second bullet point. Out of all the other bullet points, my client comes in, his name is used. And this quote, upon arrival at the Airbnb, and that's a situation that was being alleged at this point in time that the alleged victim was either potentially killed there, or that's where the initial damage was done to him. I don't want to take that in a negative way, the beating, whatever it may be, the gunshot on him. So it says, the Airbnb, Crane and Cardenas met with Mr. Pope and Brandon White. According to Pope, okay, Mr. Cardenas immediately attacked Crane and began to physically batter him. And that goes forward from there. This is their bullet points. This is the state's 32-page. And out of all the bullet points, that's all they say about my client. And we're at first-degree murder. Your Honor, we have numerous questions to go forward. At this point in time, there's no physical evidence that's being pointed to my client. There are some alleged photos that he was there with holding money up, but there were other individuals that are not even in this bullet points that are part of the photos because people were coming and going to the Airbnb. So at this point in time, I don't believe that we are at to the level of proof evident presumption's great. And I ask bond be set with understanding truly the nature of this crime, the gravity of this crime, that bond set at $1 million, Your Honor. Of course, he'll do any conditions that the state requests in regards to, for instance, turn over a passport if he has a passport, anything to that effect. Thank you, Your Honor.
All right. Your response?
Your Honor, I think we're understating the amount of preparation and planning that went into this. Really, the cold, calculated, premeditated death penalty aggravator is present in this case. What the evidence in this case through the affidavit shows is that, for lack of better terms, before the indictment, defendant A, Cardenas, made plans with defendant B, for lack of better terms, before the indictment, Prasad, in Orange County to kill Tyler Crane. And while they were making these plans and preparations in Orange County, Florida, Mr. Cardenas, defendant A for lack of a better term, was contacting Pope, Jonathan Pope, defendant C for lack of a better term at this time, who was in Dundee, Florida. There's multiple contacts between them in phone records. And about the same time that Jonathan Pope purchases the Airbnb in Dundee, Florida for the night is about when Cardenas lures Tyler Crane into his car out in Lake Nona and drives him to Dundee, Florida, where, according to Mr. Cardenas in a sworn statement that's outlined in pages 30 through 32 of the affidavit, states that there were several people there waiting with Mr. Pope and that this defendant, Mr. Whitehead, was one of those people and participated in a beating that resulted in the death of Jack Tyler Crane. That is first-degree murder. The proof is evident. The presumption is great. To corroborate that, there are the photographs, and they're not alleged. There are the photographs of Mr. Whitehead sprawled out in the driveway in front of this bed and breakfast with a large stack of money. And according to the affidavit and according to sworn testimony Mr. Cardenas provided to myself and Special Agent Mareschi and Detective Ferreira, Cardenas and the others stole $56,000 from Mr. Crane after he was beaten to death. And that was the plan, to do that. So regardless of how minor or how major one's role is, the law in this state, and really everywhere in this country, is that if you participate, if you are a principal to a crime, you are responsible for the entire crime as well. And so based on that, because this defendant, based on the sworn testimony from Mr. Cardenas and the photographs that corroborate his presence at the bed and breakfast and corroborates his presence with a large sum of money that Mr. Crane used to have, the proof is evident, the presumption is great. It's the state's position that you should hold him over as no bond, and we can have a full bond hearing with all the evidence that is set forth in the affidavit, have a full Arthur hearing in front of Judge Young, or at a time when this case gets indicted, the lowest 3 co-defendants are actually in front of Judge White. And so once this defendant is indicted, he'll be in front of Judge White. And then just as a side note, the public defender does represent Jonathan Pope already. I would submit that's a conflict and that RCC should be appointed for this defendant.
If
All
I
right. As to counsel and representation in light of Mr. Pope's representation, response?
Under criminal Florida procedure, initial appearance, an attorney as public defender can be assigned, even if our client has a private attorney for initial appearance, public defender's office can be assigned. Again, this is just initial appearance, which is not adversarial. I haven't spoken to my client in regards to the facts. Right now, we're just speaking about proof evident, presumption's great, and at that point in time, then the decision can be made going forward if Mr. Pope gets regional counsel or my client gets regional counsel at that point in time. So for right now, right here, me representing our client is the best approach so that he has his day right now for initial appearance and probable cause. Going forward, that determination will be made if regional counsel will be appointed.
All right.
If I may proceed on just a few comments that the state made, if that's fine, Your Honor. Right off, I hear everything that the state's saying. I do just want to go back to the second bullet point. It does not say anything in there, in their bullet point, in their conclusion, that my client in any way participated in the beating or anything to that effect. Nor does their bullet points or conclusion go into effect of disposing of the body, putting the body in the trunk, all these other actions that Mr. Pope, that Mr. Cardenas were part of. And I think also, too, is when we talk about the particular piece of evidence, they're talking about the photograph where my client was at the Airbnb. In fact, there was numerous other individuals at the Airbnb, and some of them were also on the photo, specifically a female that was there, which we will not discuss her name here. There's no reason to. But again, there were other people there that were part of, that had photos of them holding on to money. These are not photos where it's showing that my client in any way was involved with the murder. So at this point in time, I don't believe that there's proof evident, Your Honor. Presumption's great. So I ask that my client be released on $1 million bond and any conditions, any further conditions that the state would request, such as a passport or maybe PTR. Thank you, Your Honor.
Any response?
I want to make sure we're reading the same 32-page affidavit. I believe there was mention of Mr. Whitehead's participation.
I'm just talking about the conclusion at this point in time. I'm just reading from the conclusions, Your Honor. Their conclusion that they wrote from their second bullet point, it does not state that.
All right. Well, at this time, the defense motion would be denied without prejudice to revisit the matter.
Yes, Your Honor.
Thanks, Judge.
All right, the next file is that of Antonio Cyprin. Your name, sir?
Antonio Cibrin.
All right, sir. Sir, you have a set of charges. Burglary of an occupied dwelling, $5,000 bond. Grand theft, bond $150. Burglary of a conveyance, bond $150. grand theft, third degree of a motor vehicle, bond $150. Problem because is stated here. Now, sir, do you want me to appoint a lawyer to represent you?
No, sir.
No?
Oh, wait. Yes, sir.
All right. Office of the Public Defender is appointed, Division 20, case ending in number 15706. All right, next file is that of Kenneth Garcia. Is that you, sir?
Yes, sir.
All right, sir, you have a failure to appear capious. The judge on that case set you in a no bond status. Do you have a lawyer already appointed?
Yes.
All right, the Office of the Public Defender would therefore be appointed, and that is Division 17, case ending in number 8966.
So, Your Honor, I apologize. There was no bond? I believe the failure to appear was there was no bond on the warrant?
Right.
Okay.
All right, next file is that of Xavier Johnson.
Yes, sir.
All right, sir. Now, Mr. Johnson, you have a total of 4 no bond capiouses for failure to appear in court.
This from 2016, 2017. And I already have done time for them, sir.
All right, now I have no request for a lawyer to be appointed. Oh, all right, I'm advised the Office of the Public Defender was previously appointed, and so that appointment would remain, of course, in effect. Now, we have Division 10 cases, number 2019-5643, 3024.
Did you hear what I said?
Division 10, case ending in number 5181. And last is case ending in number 9650, Division 10. All right, next file is that of Dominic Nicosia.
Yes, sir.
All right, sir. You've got a failure to appear capious, looks like 3 counts, resisting an officer with violence, carrying a concealed weapon, and possession of drug paraphernalia. On each of those allegations, you're in a no bond status. And does the, all right, then regional conflict counsel would be appointed or reappointed in regard to these matters. All right, that's all for the moment, sir.
Thank you.
Next file is that of Raymond Rance.
Yes, sir, Your Honor.
All right, so you've got a failure to appear capious with no bond. And in regard to this matter, previously appointed the public defender, so that appointment would remain in effect. Division 12, case ending number 64420. All right, the next file soliciting without a permit. You are out on release, apparently on 2 prior cases. You were released. That release order would stay in effect. Now, in regard to the new case, do you want me to appoint a lawyer for you, sir?
Yes, sir, Your Honor.
All right, Office of the Public Defender is hereby appointed. We got Division A, case ending in number 1128.
Your Honor, the state does have an offer for the defense too.
All right, go ahead.
An adjudicated guilty with 4 days Orange County Jail, credit time served.
Let's go for that, man.
Your Honor,
Better than
my client
confidence
accepts
stuff.
offer of adjudication guilty, 4 days Orange County Jail. And I do, Your Honor, I just want to make sure I heard that you are staying on the other 2 outstanding other
Yeah.
cases, correct?
Right.
Thank you.
Hey, sir, I've been found incompetent in the past, right? And all the time, this incompetence keeps on popping up as weird as we had a haunting, and it's a stall tactic. Oh, no, I need to ask you some questions. I am competent. Yes, sir. Franklin, who's schools you? For what years? 2019. November 13th. 33rd Street, also known as Orange County Jail.
All right.
Sorry,
Now, sir, I want to hear from yourself. You have signed this plea form here. Is it your desire to plead guilty or no contest to this charge?
Yes, sir.
All right? There would be an adjudication of guilt, 4 days Orange County Jail, credit for 2 days, time served. And court costs totaling $273 payable within 1 year. All right, next file I have here is that of Michelle Denise Fort. All right, ma'am, you have a charge of trespass in a structure. Bond at this time is set at $500. Do you want me to appoint a lawyer for you?
Yes.
All right, Office of the Public Defender is appointed, Division A, case ending in number 9142. Is there any offer
Yes.
from the state?
Yes, Your Honor. The offer from the state is an adjudicated guilty, 4 days Orange County Jail with credit time served.
No doubt.
Your Honor,
Yes.
my client declines the offer from the state, which we appreciate. So at this point in time, she now
All right.
understands the bond's $500.
Thank you.
If we could decrease the bond, Your Honor, to R1R, potentially, due to it being a trespassing structure.
All right, state have any input?
Does the defendant have any failures to appear? 29. Yes, the state does object to ROR.
Say again?
Given the defense history of 29 failures to appear, the state does object.
All right, the bond then would be stayed if that plea is not accepted. And public defender appointed.
Okay.
All right, next file is that of Jesus Marquez.
That is correct, Your Honor.
All right, now, sir, you've made a request for the public defender, so the office of the public defender is hereby appointed, and also the case on which you are released, that would be stayed as to that situation. Now, you got a charge of trespass into structure, bond $500, and public defender is appointed, and that's Division A, case ending in number 9144.
The state does have an offer for the defense, Your Honor.
All right,
The defense, it'd be adjudicated guilty, 4 days Orange County Jail with credit time served.
Your Honor, my client accepts the offer of adjudication guilty, 4 days Orange County Jail.
all right. All right, there's a factual basis stated here, so the plea would be accepted by the court. There would be an adjudication, 4 days, credit for 2 days, time served, $273 in court costs payable within 1 year. All right, the next file is that of Perry. Is
Yes,
that
sir.
you, sir? All right, sir, you've got a charge here of trespass after warning. Your bond is $500. You've made the application for public defender, so that appointment is hereby made. Division A, 9143, case number. Is there any offer from the state in regard to this case?
Yes, Your Honor, it'd be adjudicated guilty with credit time served.
Because I got trespassing because I'm sleeping in my car because I'm on somebody's property.
So what we'll do is we won't accept off, and then if you don't want to, okay?
I don't know. And what's gonna happen to my car? There's all kinds of crazy crap going on. But then I'm back to square one.
That's probably what we're trying, okay?
And then I'll get charged with trespassing again.
For right now, we won't accept offers.
What to do?
Your Honor, at this
Yeah.
point in time, my client is not sure to take the charge or not. Excuse me, I apologize, the offer. So at this point in time, if he doesn't want to take the offer, we appreciate the state's offer, but we say no to it.
All right. And the public defender is appointed, so you have a lawyer.
Go back to that.
Yes.
Okay.
All right, the next file is that,
Okay.
this is from yesterday, it was here. Dennis Danhauser.
He's accused, Your Honor.
All right. Now, let's see. All right, apparently he refused yesterday, so public defender would be appointed in regard to Mr. Danhauser's case.
You know, he was bond, wages appear.
Yes, the bond is stayed, appearances waived. All right, your name, please, ma'am?
Side Kate.
All right. Now, you have a set of charges here. Possession of heroin, bond $1,000. Possession of cocaine, bond $150. Possession of drug paraphernalia, bond $100. Petty theft, bond $100. And possession of cannabis, bond $100. Now, do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is hereby appointed. And, let's see, 350. Total bonds, $1,450.
She's out on another case.
Hmm?
She's out on
Who's that? All right, now, there's a case here. Looking for the... All right, case number 2019, CF 12884AO. And the bonds total $1,350 in regard to that. Public defender is likewise appointed in regard to that case.
So, Your Honor, was the bond stayed for that case, Your Honor?
Yes.
Thank you.
All right, next file is that of Michael Johnson. Is that you, sir?
Yes, sir. Yes, Your Honor.
All right, sir, we've got several things here. An allegation of video voyeurism, 18-year older, working at school. Bond on that is $50,000. Your bond on a similar charge is stayed at $5,000. And then there's another, let me check the case numbers here. Yes. Another different case, video voyeurism, and the bond on that is likewise $10,000, Division 17. Now, in regard to these cases, I do not have a request for appointment of...
He won't need it, Judge.
private attorney.
I'm standing next to him.
Ah, all right.
Good morning, Judge.
Good morning. So, counsel is
I'm Joe Gibson, Your Honor.
already appointed. So, Division 17, cases ending in number 15406, 15405, and 14930, and Division 17.
May I, Your Honor? Good morning.
Yes.
I spoke to the state off camera, Judge, this morning with respect to an oral motion to reduce bond. I thought I had made an arrangement with the state to reduce the bond from the 50 to the 10. I wouldn't bargain against myself and ask that the bond be increased on the second case from 5 to 10, but I'd humbly ask that the court, consistent with the agreement with the state, reduce the bond on the first charge from 50 to 10. That would have a total bond, I believe, of $25,000. My client is not in danger of flight risk.
All right. A state response?
The state did agree to with the defense on the first case, 19 CF 015406, to reduce lower the bond to $10,000.
All right, so ordered. And it would appear that would conclude this matter.
Thank you, Judge.
Thank you.
verify them?
Yeah,
All three?
yes, please.
One moment. For case number 19 CF 15406, the state agreed to lower the bond to 10,000. As for the other two, 19 CF 14903, the state has the bond at 10,000. And then for the case of 19 CF 015405, the state has the bond at 50,000.
50,000?
That's what we have here. Yes, ma'am.
You need it back?
Yes.
All right, the next file is that of William Bastin.
Michael Jerome bail, sir.
I'm sorry, Mr. Bastin is in the hospital, Your Honor.
Oh, all right. Reset. All right, now, let's see. Michael Bell?
Yes, sir.
All right, sir. You have a set of charges here. Grand theft, second degree, $20,000 or more. Your bond is $24,000 in regard to that charge. Burglary of a structure, trespass on construction site, and grand theft third degree from a construction site. Bonds are each $1,000. So the total bond at this time is $27,000. And a probable cause does exist in regard to these. Now, do you want me to appoint a lawyer for you, sir?
Yes.
All right. The Office of the Public Defender is appointed, Division 22. And case hanging number 15573.
Johnson, to clarify the bond amount, because I had something different than what the state has.
Okay.
We need to clarify his bond amount.
All right, see, recall on Michael Johnson's 3 cases.
Good morning, Your Honor. Joe Gibson here.
All right, I understand there's a question or misunderstanding or clarification needed on let me just tell you what the records I have in hand show. In regard to case ending in number 15406, the bond was $50,000 and was reduced to $10,000. Then on the case ending number 15405, on which bond was already posted on that was stayed at $5,000. And lastly, video voyeurism bond $10,000, Division 17, case ending in number 149030.
I thought the court most humbly repeated the same case number twice. I thought the court indicated that the bond on 149030, Division 17, was $50,000 reduced to 10, and that under 15405, bond was posted for $5,000, and that did not then speak to 15406, Division 17.
All right, and what was your understanding as to that last case?
Your Honor, I don't wish the record to rely on my recollection of it. I thought I heard what I heard, but what I thought I heard was 10,000. That's what I thought I heard.
Well,
I could be incorrect.
That's according to the paperwork I have.
Yes, sir.
So, two $10,000 bonds, and one on which he's released, bond $5,000. That was stayed.
Yes.
The $5,000 one, that's the one that he's out on bond on, the one that stayed. But the case under that?
Yeah, okay. The $5,000 I mentioned was the case on which you are out on bond.
Right, the case under that though.
And then, so you got two $10,000 bonds. One was reduced from $50,000 to $10,000. And then the new one was already, this last new one was already $10,000. So a total of $20,000.
Question, Your Honor. So for case number ending in 15405, that wasn't 50,000 bond, it was at 5,000?
It was already been posted.
It's already been posted?
Yes, he was at liberty, Your Honor. There was no breach of the undertaking. These are all arising out of the same transaction and occurrence.
Okay, I skipped one. Case 15405, I have here still at $50,000. So, comments from counsel, the state?
Well, yeah, that's what the state's paperwork shows, that it's at $50,000 bond.
And, Your Honor, that would be consistent with the compact I made with the state attorney this morning to, like saying, reduce that to 10,000.
To what?
Under 15405, Your Honor. If that bond is 50, I'm truly confused because I thought that was the same court case number that indicated the bond had been posted at 5. So if the bond, I'm not understanding. A $50,000 bond would carry a $5,000 premium, but I'm not understanding that the bond was $5,000. I'm truly confused.
Okay, now, there is on the bond sheet for a posted bond, let's see, 15405.
No, that's not the case number, Judge, for that out on bond, it's right here.
Okay, I was in error on that case number. That's 2019 13640 AO, bond $5,000.
Your Honor, that's consistent with my understanding of the procedural posture that my client was at liberty on one third-degree felony, and that the Orange County State Attorney's Office charged 3 seconds, which is why we are here this morning. But that would be consistent in a practical sense with my understanding. Thank you, Madam Clerk. We'd ask that the bond be reduced to $10,000.
Are we, is this in regards to the case ending in 15405?
That's my understanding, yes. So I would have 15405, 149030, 15406.
All right, what's the state understanding on case 15405?
On 15405, that was when the state agreed with the defense to lower the bond to $10,000.
Thank you,
All right,
Judge.
so ordered.
Thank you, Your Honor. We're good. May I be excused, Your Honor?
Yes.
Thank you, Judge. This way out?
All right, the next file I have is that of Cody Brady Crafton. Yes, sir. All right, sir, a set of charges here. Criminal mischief, bond $1,000. Burglary of a dwelling, bond $5,000. Grand theft third degree, more than $300, less than $5,000, bond $500, for a total of $6,500. And probable cause does exist. I have now handed the request for appointment of public defender. That is granted, and this case is ending in 15712, Division 19. All right, next file I have is that of Peterson Desravines.
Desravines, correct, sir.
All right, sir. Sir, you've got a grand theft third degree charge, more than $300, less than $5,000. Your bond at this time is $2,000. Do you want me to appoint a lawyer for you?
No, I'm going with my current lawyer, Corey Cohen.
All right. All right, next file is that Jemery Gaynor.
Yes, Your Honor.
All right, sir, you've got a case here involving delivery of cannabis within 1,000 feet of bus. Bond is $10,000 in regard to that. You have requested appointment of the public defender. You do not, however, qualify for that appointment. So you would have to, at this point at least, hire your own attorney, and that's Division 12, 15718. case number.
Your Honor, may I, as a friend of the court, for the purposes solely for his bond, as his bond is $10,000, I believe there's actually a probable cause challenge. So again, as a friend of the court, I ask if I can present the probable cause on his behalf.
Certainly.
Your Honor, the probable cause is the arrest affidavit. They end up arresting him and charging him based upon within 1,000 feet of convenience or business. If we go to the statute says in 1E, so 893.131E, it says within 1,000 feet of conveyance business as defined in sorry, I shouldn't say da-da, section 812.171. And we look at that definition, it specifically says throughout the whole definition, quote, "The term convenience business does not include," and number 2 is a business that always has at least 5 employees on the premise after 11 p.m. and before 5 a.m. If we look at the arrest affidavit does not discuss the business, the convenience business inside of it. So at this point in time, there's no probable cause, Your Honor, in my opinion, the charge of within 1,000 feet of business.
All right, and state's response, please.
One moment, Your Honor.
And, Your Honor, if I may, if the state at this point in time, he does qualify for PTR, so if the state has no objection to PTR, nor does the Honor, does this court, I believe that we could proceed with PTR on this matter.
All right. Any response for the record to PTR?
In regards to PTR, yes, the defendant does qualify, yeah.
All right, then PTR is authorized and ordered. All right, next file is that of Michael Glassford.
Yes, sir.
Sir, you've got 2 cases here involving failure to appear, and on each there's a no bond status. The charges are dealing in stolen property and receiving money from a pawnbroker with false verifications. All right. Public defender was previously appointed, I'm told, so that appointment would remain, of course. And let's see, case ending in number 259, Division 22. All right, next file is that of Michael Goulet.
Yes, sir.
Sir, you've got a failure to appear capious. No bond was ordered by the court. Public defender was previously appointed, I'm told. That's Division 14, case ending in number 4746.
Is that no bond, Your Honor? I'm sorry.
Yes. All right, next files are that of Ronnie Haught. All right, sir, your name?
Ronnie Hall.
All right, sir, you have a set of charges here. You've got a case involving a threat to a law enforcement officer, public official, or family member, bond $150. Possession of a firearm in commission of a felony, bond $150. Grand theft, 3rd degree of a motor vehicle, bond $150. carrying concealed firearm bond $150, contributing to the delinquency of a minor bond $100, possession of a controlled substance with a weapon bond $2,500, trespass in a conveyance bond $100, and then
Your Honor, if the state may, with state police, the defendant was charged twice for the same charges. Like, you're about to flip to the next affidavit, and the state has conferred with the defense, and like, it seems that the officers put.
so it's a duplication, are you?
Yeah, it seems it's
All
Yeah,
right.
by talking with the state, Your Honor, at reading it, there's two rest affidavit, they both have the same numbers. Again, when I was reading the rest affidavit, it appears that one just has more detail in the context of the charges, the police officer saying how he charged each crime. If we go through them all, it's the exact same charges. The threat of a police officer, and reading through that rest affidavit, again, it's the same incident. So at this point in time, again, talking to the state, we believe that they're duplicate charges.
All right. It's got a different time of arrest, one 5:10 and the other 6:06, but that is not definitive of whether it's a duplication or not. So, in any event, the public defender is appointed, and we'll go in regard to case ending in number 15727. And it looks like, looking for the division, looks like Division 19. All right, then that concludes that matter.
So, Your Honor, on the other charges that are duplicate, what's the stance currently? Because the bond that we have right now is 150, 150, 150, 100, 1,500, and 100. So the remaining charges for right now, are we ROR?
Yes,
Can we just do ROR on the remaining charges?
let's do
And
that.
then we can determine, the state can determine if it's valid or not going forward. Thank you, Your Honor. So you have ROR.
All right,
And then that's your 2,500, 100. Yep, okay.
Next file is that of Justin John. Is that you, sir?
Yes, sir. Justin John.
All right, Mr. John, you've got a failure to appear capious, no bond, Division 19, case ending in number 8284. All right, and public defender was previously appointed. All right, next case is that of Lewis Kenneth Jones, case number 15710, Division 16.
He's mental health, Your Honor.
All right, reset. Next case is that of Fabian Lopez.
Yes, sir.
All right, sir. You have a set of charges here. Let me look at these papers. Oh, failure to appear on several number of charges, looks like 8 charges, Division 15, 16914. And public defender was previously appointed. So that's all I can tell you for the moment, sir. Next file is that of Michael Mcmillian. Is that you, sir?
Yes, sir.
All right, sir. You have a set of charges here. There was an arrest warrant issued. And the public defender is appointed, case ending in number 15678. Now, the charges. Count 1, lewd or lascivious molestation, no bond. Lewd or lascivious conduct by a person over 17, no bond. Soliciting or engaging in sexual conduct with a student, no bond. Child abuse, no bond. Contributing to the delinquency of a minor, no bond. Sir, do you want me to appoint a lawyer for you?
I would like to remain silent, and then I'll have my family appoint me an attorney.
All right.
Your Honor, for the criminal procedure for initial appearance, public defender's office can be appointed, and I asked, we're just appointed for initial appearance purposes of speaking about his bond, because one of the charges is a possibility of life. So one of those charges, he can be held with 0 bond. So I believe the state's going to have that request. I'm not sure. So I'd like to represent him. I believe it's best interest for the gentleman to my right to have counsel at this point for initial appearance.
All right. For initial appearances, granted. All right. Now, state.
Yes, Your Honor. The state is requesting no bond, and the defendant, first and foremost, the defendant was arrested on a warrant affidavit out of county, and in that affidavit, it is detailed that the victim is underage, I believe around, I'm not quite sure the age, but she is under the age of 12, and she identifies the defendant as the one who sexually abused her, and there's identification, and for the safety of the community and the victim, the state requests that Your Honor stays the bond at no bond.
If I may, Your Honor?
Yes.
So out of all the charges, the molestation under 12 years old is the only charge that he can be held at 0 bond. The rest of them, we can discuss bond in a moment, if I may. So talking about the possibility of the life charge, if we look at the warrant, and for this purpose, we only look at the warrant, the 4 corners in it, my client, first and foremost, did not confess or speak about the charges. There's no physical evidence, and there's no independent witnesses. So for a proof evident, we have a very high standard. So at this point in time, it's alleged victim and what she has discussed to the state investigators, and that's it. So again, That does not come, what we have in the warrant, to the level of proof evident presumption. Great. So I asked bond based upon his prior non-history, 0 felonies, 0 misdemeanors, 0 failures to appear, that reasonable bond of $10,000 is set for the first charge. The remaining charges, we have $1,000 for each remaining charge, Your Honor.
All right, and state's response?
Yes, Your Honor, one moment, if I may.
All right.
The state would again just like to reiterate its previous argument that the victim does identify and confess and identify the defendant as the assault on her, and there's confession from her, and as well as treatment from professionals, and the state just reiterates and requests no bond for the first count, for count 1, and if a bond was to be set, that we request a high bond be set in your discretion, Your Honor.
All right, I want to look at this for a moment. All right, I've had a chance to just briefly read the factual basis here. So, anything further?
Yes, Your Honor, just reiterate for the presumption great evident, I apologize. That standard is so high, Your Honor, it's an extremely high standard for the reason of we're taking all the information in the arrest warrant. So looking at the arrest warrant, we only have the alleged victim's allegations at this point, and that's it. We're very far from that standard. There's many questions still out there. Again, there's no physical evidence, so I don't believe the state at this point in time has reached to that level. And I ask for the reasonable bond of the $10,000, Your Honor, for the first charge, and every other charge underneath is $1,000, Your Honor, based in part 0 criminal history.
All right, and state's response now?
Yes, Your Honor, again, one moment. In the arrest affidavit, the state does put forth that the principal where the defendant worked did sign a sworn affidavit saying that the suspect admitted to the conduct alleged.
Well, to move on in regard to the issue of bond, as to count 1, the bond would be set However, it would be in the amount of $25,000, and counts 2 through 5 would be $1,000.
And Your Honor, just one more second. Speaking to the gentleman to my right as a friend of the court, after discussing with him the situation of an attorney, based upon his monetary, his funds, I do believe he qualifies for public defender. And at this point in time, if he asks the court, I think he wants us to represent him.
Please.
No, say it.
Well, it would appear that pursuant to the application for criminal indigent status, he does qualify for appointed counsel. So that representation would be allowed at this time, and certainly if he wants to hire a lawyer at a later time, that's fine. But I want to make certain he has a lawyer at this time.
Yes, sir.
All right, the next file is that of Jose Nieres. Is that you, sir?
Yes, sir.
All right, there's a set of allegations here, or charges. Lewd or lascivious conduct by a person over 17, bond, no bond, obscene communication, et cetera, bond $150, and obscene communication modified from the count 2 and count 3, bond $150, unlawful use of a communication device, bond $150 in this case.
And Your Honor, if I may be heard on bond?
Okay, just a second.
Okay.
The public defender is hereby appointed in regard to the case. Go ahead.
Your Honor, the first charge is no bond until until initial appearance. It's not a possibility of life charge. Based upon looking at his, from what I'm reading, non-criminal history, no arrests. It doesn't even show, I don't see any arrests either. Based upon that, I asked the court to stay the other bonds at $150, and the first charge is set at $5,000, Your Honor.
All right, and state.
Just given the nature of the charge, the state does request that if bond be set, that it be a high amount in your discretion, Your Honor.
All right, now, there is probable cause from the reading here. The bond as to count 1 would be set in the amount of $10,000 and $150 in regard to counts 2, 3, and 4. And public defender appointed, and case ending in number 15729, Division 16. All right, the next case is that of Taryn Porter. Your name, sir?
Terrence Porter, sir.
All right, sir, you have a charge of battery, and there is probable cause stated in the affidavit. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public Defender appointed, Division 22, case ending in number 15701. All right, now, defense?
Yes, Your Honor. Is it a matter of bond, Your Honor?
Yes.
At this point in time, Your Honor, I ask for the amount of $2,500, Your Honor.
All right, and state's response?
State has no objection, Your Honor.
All right, so ordered, and also, no victim contact. That is alleged to be Joseph Hendley, Hendley, the victim there. All right, next file is that of Rafael Santan Lorenz, and how do you pronounce your last name?
Lorenzana.
All right. Sir, you've got a charge here, an arrest warrant for robbery with a deadly weapon. There's a warrant issued in regard to this. Sir, do you want me to appoint a lawyer to represent you?
Yes. Yes.
All right. This case ending in number 15228, Division 16, Public Defender appointed. All right. Unless there's something further from defense, that concludes this case for the purposes of this hearing.
Yes, Your Honor, based upon the crime, if I'm not mistaken, the state would be able to agree with me that it's a possibility of life, if I'm not mistaken. And as such, there would have to be a discussion if the state is seeking zero bond based upon proof evident. At this point in time, I do ask, based upon his criminal history, yes, he does have a felony and 2 misdemeanors. However, we look at the convictions in there for DUI and drug paraphernalia and controlled substance. So they're not violent in nature. So I ask for a bond set in the amount of $50,000, Your Honor.
All right, and state's response?
The state does request no bond, and that in this case, the defendant is seen by multiple witnesses in the establishment and is caught on camera committing the robbery. The state believes there is sufficient evidence to prove proof of evident presumption great, and to ensure the safety of the witnesses and the community, the state requests, and even though his criminal history is minimal, he does have a criminal history. The state seeks that the defendant should be held at no bond.
In looking at the warrant, Your Honor, there's another individual that's involved in this alleged incident, I should say. And if we're looking through it, there's a lot more questions than answers at this point in time in regards to this other gentleman, which I won't say in open court because there's no reason to, but the key point is that there's another individual, and it appears that there's a little, who's done what or that. So at this point in time, again, I would say that the state hasn't met their burden. That's a very high burden when we're saying proof evident. Guilt is great. At this point in time, again, I asked for bond to be set at $50,000 based upon the warrant, having lacking information. Thank you, Your Honor.
The state would just say that the other individual in question, again, not to be named, was arrested on October 24, 2019, and confessed to the robbery and implicated the co-defendant here as well.
And that's, and if I may, Your Honor, that's the point right there. Someone else is arrested. They're implicating someone else. So at this point in time, there's a lot more information that we have to gather to determine that that confession is actually true at this point in time. There is no more evidence. I know the state's bringing up, again, other individuals arrested on it. That individual implicated my client. So at this point in time, I look at it as they have not met their burden. They're far from that burden, and a reasonable bond. And I say a reasonable bond, it is a charge that's punishable by life, and that's why a $50,000 bond, which is a lot of money, to ensure my client appears before this court for any old future matters. Thank you.
All right, bond would be set in the amount of $50,000, and you would not return to 10201 Narcousie Road and have no contact with either victim, Rafael Centeno Lorenzana or Angel E. Nunez Sanchez. And if I didn't announce it before, let's see. Case 2019-15228, Division 16. All right, next file is that of Levante Sean. Your name, sir?
My name is Levante Shaw.
All right, sir. You've got a set of charges, dealing in stolen property and violation of pawnbroker transaction form. Your bonds are $7,500 on the first charge and $250 on the second charge. Case ending in number 15502, Division 22. Now, I do have the request for a lawyer. So the Office of the Public Defender is appointed in regard to these matters.
Was there 2 cases? Was there 2 cases before the court on him right now? I apologize, Your Honor. 399 or in a 397? No, it's just a 399? Oh, I'm on the wrong person. I was on Torres. Just 1 second, Your Honor. I do not have him. I don't have him. Sorry, Your Honor. A warrant. Is there a bond amount on that warrant?
7,500 on count 1, 250 on count 2.
Hold on 1 second.
All right,
Thank you.
next case is that of Amber Lee Torres. Is that you, ma'am?
Yes.
All right, this is case number 15397, Division 16. Ma'am, you've got a set of charges here. Conspiracy to traffic in heroin of more than 4 grams, bond 100,000. Conspiracy to deliver heroin, bond 50,000. Conspiracy to sell or deliver cocaine, bond 50,000. A RICO, as we call it, violation, bond 5,000, and conduct to participate in racketeering, bond 5,000, and a warrant was issued by a judge in regard to this based on the affidavit. Now, ma'am, do you want me to appoint a lawyer for you?
Your Honor.
All right, Office of the Public Defender is appointed. Now, in regard to this, any input from counsel?
Yes, Your Honor. I believe that my math is correct. It's $210,000 as a bond, which at this point in time is paramount to no bond. So I ask, looking at her criminal history, which I jumped to very quickly, is 0 felonies, 2 misdemeanors, 0 failures to appear. There's no trafficking charges. There's no a felony-wise, some sort of drug trafficking charges. So at this point in time, I ask for a reasonable bond, that we take the $100,000 down to $10,000, and then the heroin and cocaine selling deliveries, $5,000 each, and then remaining the RICO and racketeering at $5,000, Your Honor.
All right, State have any response?
The state doesn't object to count 1 being reduced, but as for count 2 and 3, the defendant was arrested on a warrant, and she did have, and the original offense she had was for another RICO charge and conspiracy to traffic heroin, and she has another case pending, 15399, in which she also had multiple drug charges and sale to deliver. So the state would object to count 2 and 3 being reduced.
Well, in regard to these allegations, the count 1 bond would be reduced to $25,000, count 2, $5,000, count 3, $5,000, and counts 4 and 5 bonds, $5,000. Oh, all right, I neglected to look at the second case in this file. All right, I did neglect it, case ending in number 15399, Division 12. We've got sale, delivery of fentanyl, bond $15,000. Sale, delivery of heroin, bond $5,000. Delivery, sale, delivery of cocaine, bond $1,000. Conspiracy to sell or deliver heroin, bond $150. Conspiracy to sell or deliver cocaine, bond $150. And unlawful use of a two-way communication device, bond $150. So the Office of the Public Defender is appointed as to that case also. Now, any input from either or both counsel in regard to this case?
Yes, Your Honor. We were at $45,000 for the previous case. At this point in time, I asked that we just hold the one bond, the fentanyl at $15,000, and all remaining subsidiaries at $150 each. So that would be the second count at $5,000 be $150, and the sale of cocaine, which is $1,000 be $150.
And state?
The state would object to counts 2 and 3 being reduced, and that they should remain as is, and that from these charges and from her other case, CF 15397, she does have history with drug offenses and trafficking drugs. Your Honor.
Well, with respect to count 1, the bond would be $7,500. Count 2, $1,000. Count 3, $150. And counts 4, 5, and 6, bond $150. All right, next file is that of Jessica Torres, Division 20, case ending in number 15676. All right, in regard to this file, the existing conditions of release or bond, if any, would be stayed. And then this new case, public defender appointed, and let's see. Now, as far as this is concerned, count 1, the court is increasing the bond from $1,000 to $5,000. Count 2, 100. Count 3, 100. And count 4, 100. Do you want me to appoint a lawyer?
Public defender, yeah.
All right.
Yes.
Public defender appointed. Again, Division 20, 15676, case number.
Joseph Williams is mental health, Your Honor.
All right, now, let me make sure I've got the next one straight. Joseph Williams Jr.?
It's mental health, Your Honor.
Okay, that's the mental health. Okay, reset. All right, your name, please?
Abdurrahman Bentakur.
All right, sir, you've got a set of charges: disorderly intoxication, bond $250, petty theft, bond $250, and assault, bond $250. You want me to appoint a lawyer for you?
Yes, sir. Please, sir.
Public defender appointed, Division A, case ending in number 9157. And the court is adding a condition of release, and that is that you not return to 12236 South Apopka Vineland Road in Orange County.
Yes, ma'am.
Was other matter stayed, Your Honor? He's out in ROR.
Oh, yes, that's correct. All right, the next case involves two files, apparently. Deborah Lynn Montez?
Yes, sir.
Your Honor, if the state may, this is the same duplicated instance as we had in the previous case with
Mr. Hott.
Mr. Hott.
She's a co-defendant with the case that we had previously in regards to two affidavits. Ms. Moats is, and the two separate trespassing, it's 1024 and then 1023. And again, these are the exact same arrest affidavits that was used against the other gentleman. And so that trespassing, talking to the state, at this point in time, we're seeing that the two trespassing charges, it should just be one trespassing charge. So I believe that the state would have no disagreement, if I'm wrong, of RORing on the second trespassing.
They had an offer to.
All right, so ordered.
So would that be a RO on both, Your Honor?
Let me. All right.
Thank you, Your Honor.
Well, wait, the state doesn't agree to ROR, the objects to an ROR, given the defendant's history. For the second charge, not the.
All right, ROR.
Thank you, Your Honor.
Yes, it is. right, the next file is that of Michael Quick, case number ending in 9148, Division A, Public Defender appointed. And the bond listed here is in the amount of $500.
The state does have an offer for the defense. Defense wasn't willing to hear. It's adjudicated guilty, 4 days Orange County Jail with credit time served.
Your Honor, my client accepts a plea no contest, adjudication guilty, 4 days, Orange County Jail.
All right. All right, now, Mr. Quick, you've signed this form here. Do you understand you'd be forever giving up your right to have a trial on this?
Yes, sir.
Is that what you want to voluntarily do?
Yes, sir.
All right. And in regard to this case, there would be an adjudication of guilt, 4 days, credit for 2 days, time served, $273 in court costs payable within 1 year. All right, next file is that of Tyler Thompson. Is that you, sir?
Tyler Thompson.
All right, now this is county ordinance violation.
Well, the state does have an offer of the, I don't know if we're waiting, but the state does have an offer of adjudicated guilty, credit time served, Your Honor.
Your Honor, my client accepts offer, adjudication guilty, credit time serves, and pleads no contest.
All right. All right, so Mr. Thompson, do you understand you'd be giving up your right to a trial by entering a plea?
Yes.
All right, then the plea is accepted. There's a factual basis stated here. There would be an adjudication. Time served, that would be 2 days. Time served, Orange County Jail. Court costs $273 payable within a year. Thank you. All right, the next file is that of Cesar Villanueva Cordero. Ma'am, what is your name?
Elizabeth Azar, a.k.a. Whitmire.
Villanueva is Spanish interpreter case, Your Honor.
All right. Reset or
That's his
pause.
Yeah.
Okay. Next case is that of Elizabeth Azar.
Yes, sir.
All right, ma'am, you've got a charge here of retail petty theft, Division A, case ending in number 9164. You want me to appoint a lawyer for you?
Yes, please, Your Honor.
All right, Office of the Public Defender is hereby appointed. And is there any offer from the state?
She's active state probation, Your Honor.
The state does have an offer at this time. It would be adjudicate guilty, 5 days Orange County Jail with 2 days credit time served.
We do appreciate the state's offers, but we're going to have to not accept it today, Your Honor.
All right. So the bond is $250, public defender appointed. All right, next file is that of Felicia Brown Williams.
Yes.
Ma'am, you've got a Volusia County warrant for violation of probation. No bond at this time. It's on a cocaine case, apparently. So what happens is you'll be transported to Volusia County to answer to the charges there.
Mm-hmm.
That's all I can tell you right now, ma'am.
Okay.
Mhm.
All right, next case is that of Mark Grandara.
Yes.
Sir, you've got an Osceola County case, and your bond is $1,000 in regard to that.
Yes.
So I can't tell you anything about the charges, but bond is $1,000, as I say, and you can pay that bond here or be transported to Osceola County and pay there.
You want to take any action on the one he's out on the bond on and the one at Orange County?
Oh, yeah. And the bond is stayed on the Orange County bond of $3,500. All right, the next file I have is that of Gregory Brooks.
Yes, sir.
Sir, you've got a Lake County warrant on which your bond is $1,000. And it looks like a drug type charge. So you can post a bond here or be transported to Lake County to handle the case there.
And Your Honor, are you staying, he's out on bond? Will you be staying that out on bond on that case?
Yes, yes, thank you.
All right, thank you, sir. I appreciate it.
Nathan Franklin is medical, Your Honor.
All right. Now, it looks like that's the second day medical. All right, Office of the Public Defender is hereby appointed on that case. Then the next case I have is that of Jeremy Rogers. Is that you, sir?
Yes, sir.
All right, sir. You are out on bond on case. That one is stayed. Now, you have a new set of charges, carrying a concealed weapon, bond 500, 2 counts of that, and the second bond is listed as $100. And do you want me to appoint a lawyer for you, sir?
I was going to use a public defender.
Yes, public defenders are lawyers.
Yes, sir.
All right. Public defender is appointed, CRA, and case ending in number 9125.
Sweet, thank you. Thank you very much, sir.
All right, then apparently that's all for the moment. How long do you request for?
Public Defender's Office, legal counsel, other legal counsel has already reviewed the cases, so it's just a matter of time for me to retrieve the cases and speak to our client, so 30 minutes. If that's sufficient for, I'd want to make sure the state has.
That's 30 minutes as well.
Okay, 30 minutes it is. That'd be.
The child neglect of a child, great bodily harm, disabled. Statute 827.03, was there a bond that's set for that?
No, that is at this time in a no bond status.
And that's due to the nature of her initial appearance. It's not a PBL. So at this point in time, I asked that the court if they would make the bond set at $1,000, Your Honor.
All right, and state?
Your Honor, the state's recommendation on that would be, as it's a different charge from the prior 3, the state would ask the court to set bond at $5,000 for that count and stay the bond as to 1 through 3 and 5.
All right, so that request would be granted, and the bonds remain the same, except for count 4, instead of no bond, it would be $5,000.
And Your Honor, the state would also ask for a possess no weapons, firearms, ammunition, or incendiary devices order, and no unsupervised contact with any child under the age of 18.
Well, at the moment, it appears that would be appropriate to order that condition, and all the conditions that have been requested.
Your Honor, if I may, speaking to my client, and again, this is what I'm hearing right now, it appears that DCF has been involved, and I would ask if we take the approach of what DCF puts forward as her contact or not contact, that we just take this approach at that time. depending on what the DCF says, and we take their direction.
And Your Honor, then the state would also ask the court to order that she comply with all conditions and terms set about by DCF and comply with any DCF investigation. But the state still requests a no unsupervised contact with anyone under the age of 18.
All right, those requests would be granted and appear appropriate.
And we're just saying unsupervised at this point in time, the state. Unsupervised.
And whatever
The DCF says.
she has a prior child neglect conviction. Felony.
All right, next file is that of Mr. Henry.
Yes, sir.
All right, sir, you've got a charge of carjacking with a firearm on which there is probable cause. Do you want me to appoint a lawyer for you?
Yes, sir.
Public defender is appointed, and that is Division 11, case ending in number 15726.
Your Honor, if we may be heard on bond, I believe at this point in time, the state would have an argument for zero bond, if I'm not mistaken, if they'd like to proceed first.
Yes, Your Honor. The state would ask the court to take into consideration the sworn affidavit and the facts that are contained within the arrest affidavit that have an identifiable victim or witness, and that identifiable victim or witness did provide facts to law enforcement that led to the arrest of Mr. O.K. Henry III, and the state would ask the court to find that proof is evident or presumption is great that Mr. O.K. Henry III is one of the two males that was so identified. Based on that fact and a finding of proof evident or presumption great, the state would also ask the court to take into consideration Mr. Henry's his history, which contains a conviction for carrying a concealed weapon, and also contains dangerous crimes, arrests, burglary of dwellings, and aggravated domestic violence, aggravated battery domestic violence. These are all violent crimes. And based on that, the state would ask the court to continue to hold Mr. Henry at no bond on this matter.
If I may, Your Honor?
Yes.
Taking the arrest affidavit, and again, taking the arrest affidavit, information that's in there, not any information speaking to my client. My client says that he had permission from taking the car due to the alleged victim paying for debt, drug debt. And also, too, there was not a gun found. So that information right there that's provided in the arrest affidavit, that alone does not allow the state to make the argument it reaches to the level of proof evident, and presumption great. At this point in time, taking consideration my client's background and criminal history, I will acknowledge that we do need to ensure that there's a bond that's set to the level that my client will attend court dates. And so at that point in time, we asked for a bond to be set at $75,000, Your Honor.
All right, any response from the state?
No, Your Honor, other than the fact that Mr. Henry was identified in this F1 punishable by life offense. and Mr. Henry was in possession of that vehicle. He was identified, caught in the vehicle, and the victim did make a statement that is contained within the sworn affidavit that there was a gun involved. That, coupled with his history, the state believes warrants his being held at no bond at this time without prejudice, for that matter to be heard later.
And just one last comment, Your Honor, if I may. Again, right now where we're at, the standard is very high for proof evident presumption great. And right now, at this point in time, the alleged victim's statement versus what's in the arrest affidavit in regards to payment of drug debt, that it actually was given to him, that he had permission to use it, and there was no gun found, Your Honor. Thank you.
Well, at this time, without prejudice, the defense request is denied, considering the facts set forth here, and that is Division 11, case ending in number 15726. All right, John Huff.
Yes, sir.
Sir, you've got a charge of second-degree arson, bond $2,500, and criminal mischief, bond $1,000. Probable cause does exist, as stated in the arrest affidavit. That's Division 17, case ending in number 15724. And you do want a lawyer appointed, is that correct?
Yes, sir, please.
All right, so ordered, public defender appointed. And case ends 15724, Division 17.
Your Honor? I apologize, I didn't hear the bond amounts, Your Honor.
All right, count 1, 2,500, count 2, 1,000. All right, next file is that of Johnny Johnson, case ending in number 15721, Division 15. Is that you, sir?
Johnny Johnson.
All right, sir. Now, you do have a total here of $2,500 in bond. Again, totaling all of these, Division 15, case ending in 15721. Now, Sir, you want me to appoint a lawyer for you?
Yes.
Public defender is appointed, Division 15.
In your honor, the bond amounts were 1,000, 1,500.
$1,000, $1,500. Next file is that of Antoine Owens, Division 12, 15725.
Good morning, Your Honor.
Morning, sir. Sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender is appointed, Division 12. And in regard to this, probable cause does exist. And I believe that's everything for purposes of this court appearance. All right, next file is that of Lonzo Thomas, Division
Yes, sir.
17, 15723. Is that you, sir?
Yes, sir.
All right, sir, you are released on a bond on drug and trespass charges. That bond is stayed. Now, you have new charges here. Possession of cocaine with intent to sell or deliver, bond $15,000. Trespass on property after warning, that bond is $100. Now, sir, you want me to appoint a lawyer for you?
Sir.
All right, Office of the Public Defender is appointed, Division 17. All right, next file is that of Jehan Tano Vincente. Am I close? All right, sir. This is Division 20, case ending in number 15720. And we have a set of charges: burglary of a dwelling with assault or battery, criminal mischief, and possession of paraphernalia. No bond on any of the three charges. And,
What is my charges? Sorry, excuse me.
sir, you want me to appoint a lawyer for you?
Sure. Yes.
All right, public defenders appointed, Division 20.
In your honor, an amount of bond, if we can, due to the nature of the crime, I believe the state would want to discuss the first charge. If not, I can proceed. I ask your honor, at this point in time, that that reasonable bond be set in the amount of $5,000, $150, and $150, your honor.
Like, I was looking for my friend.
However, the state would like to be heard as to bond. The state was just responding that the state is not going to make a
Oh, sorry.
evident presumption. Great. argument in this matter.
That machine's going, I couldn't hear you. What?
The state was just indicating to defense counsel that I'm not making a proof evident or presumption great argument in this matter, though this is an F1 punishable by life offense. However, the state would like to be heard as to bond and as to a reasonable bond for an F1 punishable by life offense. And the state would ask the court to set bond as to count 1 at $75,000, set counts 2 and 3 at $150 for count 2 and $100 for count 3 as subsidiaries. The state would ask for an order of no return to the scene, no contact with victim or witnesses, possess no weapons, firearms, or ammunition, and that is all that the state is requesting at this time. The state would submit to the court that $5,000 for a punishable by life offense is not an appropriate bond.
If I may, Your Honor?
Go ahead.
And Your Honor, Mr. Tina Vicente also has crimes of violence in his history as arrest, domestic violence, battery, twice. This is also a crime of violence.
Your Honor, listen to the statement and description of his criminal history, and the state has to discuss it about the amount of bond. $75,000 to my client would be paramount to no bond. However, taking consideration his criminal history, I do believe at this time that more reasonable bond to ensure that my client does appear to court is at $15,000, Your Honor.
All right, with respect to count 1, bond would be set. It would, however, be in the amount of $50,000. Count 2, $150. Count 3, $100, with conditions: no return to 6043 Nashua Avenue in Orange County, and no contact directly or indirectly with any resident thereof. Possess no weapons or firearms. And that is everything for the moment. All right, your name, sir?
Gregory Linnell Turner, Jr.
All right, thank you.
Yes, sir.
And, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public Defender's appointed, Division 10. And, sir, there's a charge here that you're facing: possession of methamphetamine, bond $1,000. And that's Division 10, case ending in number 15722. Do you want me to appoint now a lawyer for you?
Yes, sir, please.
A public defender is appointed.
And Your Honor, for the matters of bond, it's currently saying it's $1,000. My client does qualify for PTR and also take in consideration just the crime.
All right, PTR would be allowed.
Your Honor,
Yes.
with regard to pretrial release, the state would like to be heard as to pretrial release.
All right.
Though his prior failures to appear are somewhat remote, he does have failures to appear. His convictions also include such matters as fleeing and attempting to elude police officers. And that would be indicative of someone that would evade forms of judicial process and arrest process. He has 5 felony convictions, 6 misdemeanor convictions, and 5 unknown dispositions. His arrests include crimes of violence such as battery, and he has prior failures to register as a criminal offender, and the state would ask the court to set bond in this matter as opposed to releasing him on pretrial release. If the court is inclined to release him on pretrial release, the state would ask that that pretrial release include random urinalysis.
And if I may, just very quickly, Your Honor.
Go ahead.
In regards to him not showing up to court or his previous past arrests, I would say this, Your Honor. My client's being charged with MDMA ecstasy. He was not charged with resisting arrest or anything to that effect. In fact, he was just riding his bicycle. Again, this was alleged in the affidavit, improper lighting, and he had a consensual search, which resulted in the drugs. So taking this case into consideration, the PTR for this drug possession, I ask that the court allow for PTR.
And from our clerk, is there any history here that would be relevant?
Your Honor, just to reiterate, he does have 5 felonies, 6 misdemeanors, 2 failure to appears, and his last FTA was on 2013. He does meet the criteria for PTR, it is a drug charge, so we would just say that, Your Honor. So.
All right. Well, considering that, the court at this time would require a bond in the amount of $500 instead of the PTR.
Your Honor. It's sent over to the next person.
All right, the next file is that of Britney Frenkel. Your name, ma'am?
Britney Frenkel.
All right, ma'am, you've got a failure to appear, capias. And the bond was set well, let's see, you had originally a $950 bond, and that was recently set. Now, I also have this information. You were placed on probation the 1st of August of this year. You didn't comply with all instructions given by your probation officer when you failed to keep appointments on October 3rd and 14th. You failed to pay $150 in arrears, failed to obtain mental health evaluation, failed to obtain drug and alcohol evaluation, failed to comply with the conditions of the collections program. So the recommendations are either a $950 bond to get out of jail, that if you wanted to enter a plea at this time, you'd be recommended to serve 120 days Orange County Jail, revoke and terminate probation, and to still be liable and required to pay the cost of supervision to collections. So that's the recommendation. Now, at this point, I'll consider first comments from the state, followed by from the defense.
And Your Honor, if I may, just as to probation's recommendation, it does not, unless the state conveys that recommendation, it is not to be considered as an offer to resolve the case. I do see probation's recommendation here. I just have not had an opportunity to review it to see if the state would, as it is a recommendation that is on an underlying domestic violence battery case, and there's no indication that the underlying victim was contacted regarding this recommendation. The state will not be conveying that recommendation, so the state would recommend to the court that the bond be stayed at, I believe it was $950. I'm not sure if that's what the ultimate bond is.
Yes, that was the recommendation. All right, now from the defense.
Your Honor, if we
Yes.
may just, at this point in time, decrease the bond to $500, Your Honor.
Your Honor, as that bond was set by the trial division, the state would ask the court to stay that court's bond amount.
The defense is okay with staying at $950, Your Honor.
All right, so we're stayed at $950 and PDR is not imposed. All right, the next file is that of Jose Concepcion. Is that you, sir?
This is driver's license history.
All right, sir. So that is your name, correct?
Yes, sir.
All right. And Sir, do you want me to appoint a lawyer for you?
Yes.
All right, public defenders appointed, Division A, case ending number 1025, resisting without violence, and then driving while licensed suspended, bond $500. Now, all right, I've got the record pertaining to driver's license. And let me see. On the first couple of pages, you have at least 26 traffic type charges. Lots of failure to pay required toll and driver's license suspensions, license suspensions for failure to pay fines. It starts at, let's see, 2010. Oh, excuse me. I was looking at the wrong line. That was a 2019, October case. You do go back to 2005. No, that's May of 2011 instead of 2005. But in any event, I have it looks like 3 pages of, let's make that 2 pages of driver's license type or traffic offenses. So, all right, now, in regard to that, at this time, your charge is driving while license suspended, knowing that your driver's license was suspended. Bond was set at $500. And sir, do you want me to appoint a lawyer to represent you?
Yes, sir.
Public defender appointed, Division A. And can't read that case number at this point. In any event, your bond on this case was set at $500 with a requirement. You not drive a motor vehicle without a valid driver's license. So, in regard to this, I may have gotten ahead of myself, I don't know. In any event, comments from defense, if any?
No, Your Honor.
All right.
Thank you.
All right, the next file I have is that of Ortasia Ellis. Is that you, ma'am?
Yes.
Oh, this is an out-of-county warrant out of Dade County. And let's see what we have. Aggravated assault with a deadly weapon, no bond, and they say they will transport you to Dade County to answer to the charges there. And the bond here on retail theft in the amount of $2,000 would be stayed. So you've got that Dade County case to take care of. All right, the court's in recess.